afternoon, everybody. Welcome to this week's edition of Compliance Risk.io. Today, we have a very special guest with us here today who will be talking about with us about data privacy and how it relates to cybersecurity. Without further ado, I will let you introduce yourselves.
All right, perfect. Hi, everyone. My name is Adaku Nwachukwu. I am a IP, technology transactions and data privacy and cybersecurity attorney. I've been in practice since 2004, and I've worked in the government, in nonprofit biotech company. I've also worked in big law, and I currently have my own practice. So, I know this audience is in the area of cybersecurity and data privacy. So I think it's important that you guys have an understanding of all of these new privacy laws, whether it's global or state specific, and how these laws relate to cybersecurity. Cybersecurity is really a foundation for data privacy and data protection and privacy law. So my presentation has a lot of information. I'm going to try to get through it quickly, and I'd be happy to answer questions as we go along. Not sure we're going to be able to make it through the whole presentation, but it's, I'm going to do my best. There is a lot of information, and it's going to be, I think, a really interesting presentation. So, privacy laws, how and why cybersecurity is related to privacy, and basically why it's important.
It is very important. So I'm just going to give a couple housekeeping pieces here, and then we can get right into it. So, so chat is open. Question and answers is open as we're going along. And if you have questions or chat, I'll be monitoring that along the way, and we'll try to see if we can answer your questions along the way. There is a lot to discuss here. We're very excited. This is part 2 of a series that we did this past summer, and hopefully we'll get some new and additional information. I'm very excited about being able to work again with you, and yeah, this is fun. So take it away.
All right, perfect. And yes, Tim, if you can pop in and let me know if there are questions that are applicable so I can answer then and there, because the way my computer is set up, I can't really see the question.
For you.
Awesome. All right, so basically privacy is something that in the past few years has become extremely important in a lot of states and in other countries in the world. It's something that is in the forefront, and it's very closely related to cybersecurity. To jump right in, so there are different categories of privacy, information privacy, right? Your personal information, your tax returns, things of that nature. Communication privacy, when you're talking on the phone, when you're sending emails. Bodily privacy, the police can't search you without probable cause. Someone can't really touch your body, or you can't have, a doctor can't have an operation on you without your consent. Territorial privacy, that deals with sort of your personal property, your house, even certain things, your desk at your job, a student's locker. Those are considered privacy, and there are different laws that relate to those types of privacy that you have more privacy or less privacy depending on certain circumstances and situations. So the fundamentals of privacy, I think this is very important. There's the fundamentals of privacy, individuals' right to privacy, Then you have controls on that information flow, information lifecycle from data collection to data destruction, and the management of all of those things, the management of the information during the information lifecycle. And that is situations where cybersecurity professionals will be involved in the controls of the information, the management, and assisting in the various lifecycle areas. Information security and cybersecurity. All of you guys know this. This is sort of what you do. I'm not telling you, you guys already know. So you understand confidentiality, integrity of the information, the availability of the information, and the security controls. These are some of the baselines for how companies have to consider their information security and cybersecurity as they are managing their business and trying to maintain confidentiality and security of certain types of information. So privacy law. So privacy law is very general, what we think about it. I told you the various categories of privacy law, of privacy, but privacy law these days is really focused on that personal data, personal information, privacy, the ability to control, to access, to limit it. And when you hear data protection laws, that's basically a synonym. In other jurisdictions, they use data privacy, data protection laws. We in the US usually say privacy laws.
So yes. If I'm not mistaken, I think the last count was 26 states either already having privacy laws on the books or about to this year. I know it was Utah that just came out with one. I know we know California has one. I think the last count when I saw a couple weeks ago was 26 or so states already have or in the process of ratifying privacy laws this year. I'm assuming that you're probably way versed in that better than I am about which specific states and stuff. Yeah.
Right. So basically nearly half or over half of the states have or are currently implementing a comprehensive privacy law for applicable to their state, right? Because the United States generally does not have a federal privacy law. The US only have specific categories of privacy law protected under federal law, and we'll get into that a little bit. But there are actually only 4 states that have passed comprehensive privacy laws. Majority of the states have state data breach laws, which that is, we're gonna talk about that also later, hopefully. And that is where you guys have a lot of your, data,
client data, your data,
clients, because state data breach laws go hand in hand with the privacy laws. Some of the privacy laws, they complement the current data privacy, the data breach laws. But only 4, and we'll get into those 4 a little bit later, actually have passed the comprehensive, and California being the first. All right. So obviously, this is very self-explanatory as far as why we have privacy laws and data protection laws. It's really to protect the personal data and to limit how companies can use and share that data, and requiring those companies to provide certain information and notices to clients. And you guys as cybersecurity professionals, depending on what you're actually doing with the personal data, you may fall under some of these requirements as a service provider who has access to this personal data. And so whether it's under GDPR or California Consumer Privacy Act or HIPAA, you may have to sign certain contracts with certain obligations. And you also, some of these privacy laws that I'm going to discuss and some of these requirements you guys have to be aware of and implement as a result of the contracts you're signing with your clients.
Yeah, so we are definitely seeing a lot of, I'll use the marketing term flow down, or basically requirements from the entities and organizations that we protect, those things being passed on to us. When I talk about the defense supply chain and CMMC, we talk a lot about flow down, but overall shared responsibility, right? And that's really, that's like the bigger buzz term that everybody's using these days. Is HIPAA is a great example, right? Having a BAA in place between myself and my HIPAA client, and then all their other clients as well, right? Because with the recent breaches that we've seen over the last 24 to 36 months, managed service providers are a prime target because they have access to so many individual organizations along the supply chain, which is yet another buzzword that we keep hearing about.
Exactly. No, absolutely. And as you mentioned, HIPAA is probably what a lot of cybersecurity professionals are much more familiar with, because HIPAA has been on the books for so many years. But as I have mentioned, 4 additional states have required what we call the comprehensive privacy law, and they're going to require the company that is maintaining and controlling the personal data to have contracts in place and have obligations on the service provider.
Which of the 4 states? I know California, Utah recently, Colorado, and Virginia. Yeah, I know there was something going on in Louisiana as well. Maybe I'm thinking something different, but yeah, Utah was the one that I meant just came on not too recently.
Yeah, absolutely. And let's keep our eyes out, because so what has happened a lot is in a lot of these states, the legislation has passed in one house and waiting for the second house or waiting to be signed. So I'm pretty sure, if we speak again in 6 months, we'll probably have a couple more states to talk about. But it's something, a lot of states are moving in that direction. So talking about, from states going back to the federal, as you guys are probably familiar with, HIPAA is related to protected health information. So that's going to deal with hospitals and doctors and insurance companies, basically that medical information and everything related needs to be protected. And HIPAA has certain security requirements that the covered entities, which are the companies that are collecting the data, and their service providers, their business associates, have to comply with those security measures. The GLBA, Graham-Leach-Bliley Act, something that deals with consumer financial information, as those bank institutions have to protect the personal information, which relates to financial information of individuals, where they are maintain and collect the data. COPPA is the Children's Online Personal Information Privacy Act. So for children under 13 years old, companies, especially companies online or having some type of artificial intelligence, a way of collecting data indirectly, companies have to protect that data and get consent from parents. And then GDPR is the general data protection regulation, and that's in the European Union. And in the European Union, there's the requirement that before a company can collect personal information, they have to opt in. That consumer has to opt in to the data collection. This is very different than the US. The states require, these 4 particular states require, hey, companies, you guys can collect the data, the personal information, but you have to give these consumers an opportunity to opt out, except when it comes to specific categories of information. They call it sensitive data, sensitive information. For sensitive information in those 4 states, there is an opt-in.
So before we move on here, there was a question that was asked, right? And since you have the legal background far better than I do, you know, we mentioned briefly about a BAA for HIPAA. Do you see that construct or that idea of a business associate agreement, a BAA, in place in other industries beyond HIPAA and or other COPPA, GDPR, other frameworks and other things coming, at least from your legal perspective or background? I'm not asking for legal advice.
Right.
I'm saying you in the space know that better than we do.
Well, Tim, thank you for reminding me about my disclaimer that I should give at the beginning of my presentation. Everyone, this presentation is for informational purposes only. This is not legal advice. This is definitely a discussion. This is to inform you about current laws on the books, and I will always encourage you guys to ask additional questions. Any of your legal reps and attorneys that you guys work with, ask them about it, and feel free to look at some of the information that's online. And with that, yes, the answer is yes. HIPAA is sort of the great explanation or example of having a company require its service providers to sign contracts. Now, GDPR, General Data Protection Regulations, went into effect in 2018. And one of the things that happened is that the service providers that companies use are, a company is responsible for their actions. So in order for a company to ensure that those service providers are complying with the strict requirements of protecting data of the personal information of European associates, companies are signing what we call a data processing agreement. And that data processing agreement is basically saying, these are the obligations of the service provider. These are the obligations, and they're called the processor under GDPR. These are the obligations of the controller, the person, the company that is maintaining and collecting the personal data.
Yeah, and we actually, so our government contracts aside, we do a lot of work with foundations and smaller, mid-size organizations just under the federal level, for example. I won't name them who they are, but you'd probably recognize who they are. And we do a lot of work with them. And in these contracts that we're working with, there's literally pages of data protection. What are you doing? Who has it? Who's the custodian? How's the flow?
Yes.
I mean, all that stuff comes to me to help the project manager figure out what we're protecting, what we need to protect, and so on and so forth. So, I mean, it's not just HIPAA. I mean, everything is going to be, where is your data and how are you protecting it and what agreements are in place?
I work with a lot of clients that are service providers that have clients in the European Union, and some of those clients that are controllers, meaning the company that collects and uses the personal data, they also have work in California, for example. So their data processing agreement will include information related to GDPR, which is the law in Europe, and CCPA. And I'm pretty sure very soon it's going to also incorporate those other states. We do
a lot of cross framework, compliance work between so risk management frameworks, HIPAA, COPPA, GDPR. We're going to talk about that in a little bit, but if I'm working with a HIPAA client in California that has an office in New York, I'm doing 3 frameworks with that, right? And I'm working on 3 different sets of controls that they have to adhere to.
Yeah, yeah.
Yeah.
And you know, and I'm not quite sure how much counseling into the depth, how deep you guys counsel different organizations, but depending on what the laws are, there's a lot to do, from assisting companies to figure out how to respond to, you know, a consumer's right under CCPA or GDPR. And another thing, unfortunately, last year, I'm going to say 2020, 2 years ago, the United States, I know the past couple of years is a blur.
It's a blur.
The United States is no longer considered a country that has a strong enough privacy and data protection laws to allow European countries to transfer data to the US.
Right.
So in order to do that legally under GDPR, companies now have to do, and usually it's in association, and it's part of an addendum of a data processing agreement. It's called the standard contractual clauses. And those standard contractual clauses, you can't even revise it. You can't negotiate it. There are a couple of places where you can, you know, choose option A or option B, but you can't negotiate those terms. And as a service provider, you guys are going to have to comply with it. So make sure you guys have your own internal processes and procedures to protect the data in you know, as you're also consulting and advising your clients on what to do to protect their data. This is like an amazing area. So, you know, this is probably one of the hottest industries, whether it's law or the general data privacy, cybersecurity industry. So, as I mentioned, there's no federal data protection law that covers all industries. There's, you know, there's work on the Hill in Congress right now to try to pass such a law, but we don't have it yet. And you know, we do have, as I mentioned, the couple of federal laws, GLBA, COPPA, and HIPAA.
Yeah, it's only a matter of time until, you know, if the feds aren't going to do it, the states are going to do it. And at some point,
right,
you know, we're seeing this in the industry, in the compliance industry, the lack of one global type of either privacy law or control framework, everybody's jockeying for position.
Right, absolutely. The one thing I did want to mention is, despite the fact that the US doesn't have a general privacy law for all industries, there is an area that the federal agency, the Federal Trade Commission, does have enforcement rights, and that's to ensure, for example, you guys are probably familiar with privacy policies. So if, you know, advise your clients, whatever their privacy policy is, if you guys are in the business of drafting and or reviewing privacy policies, or assisting companies in implementing their data privacy laws, right? I mean, in their internal security measures, and you're reviewing their privacy policy, it's very important that you guys make sure that what they're actually doing and say they're doing in their privacy policy is what they're doing. If not, they can get in trouble. So that's something important to just mention when it comes to privacy policies that are on websites, mobile applications, and things of that nature. And that definitely falls into what you guys are doing. So, you know, if you let your customers know, hey, do you say that you collect this type of data because you're collecting this type of data? Do you mention that you have a secure firewall? You don't have a secure firewall. We have to make sure you implement that. So those are the things that you guys, you know, why it's important to sort of have an idea of what's going on in the privacy laws. And again, Federal Trade Commission looks at privacy policies and if there is a gap, a company can get in trouble. So that's a place where you guys can be helpful to companies.
exactly.
All right. I don't want to spend too much time on HIPAA. We went through this in my last presentation. And I think you guys are very, very familiar with what's going on with HIPAA, what's going on with, the rules that are required. The basis for HIPAA and GLBA is really maintaining that those security controls, administrative, technical, and physical security when it comes to protecting that certain personal information and personal data. HIPAA, you guys are probably familiar with privacy rule, the security rule. Again, this is exactly what I mentioned about having these in place for the protected health information.
Yeah, I would venture to say, looking at the list of those that are here, I know most of these people that are attendees, and they have a pretty good understanding of HIPAA.
Yeah, yeah, very good.
You can dump a couple. If you have any questions about HIPAA, you can add them in chat.
Yeah, let's do that. Just very quickly, some of the violation. What do I want to say? The penalties and enforcement when it comes to HIPAA. So it can get very expensive, and it's very important. Companies comply with that. Now, the Gramm-Leach-Bliley Act is again dealing with financial institutions and businesses that offer financial services and products. Personal information includes all of these things: credit card information, social security numbers, etc. And GLBA have their own requirements. It's called the safeguard rules. Again, administrative security, right? Have your documentations in place, who actually has access to certain, databases with personal information, your technical security, firewalls, virus protection, now that, we're working from home, VPNs.
All the buzzwords that us MSPs and us IT professionals know.
You guys know all of this. You guys would probably teach me more about this stuff, because that's what you guys do every day. And then, the physical security, key cards coming in and access to certain rooms and things of that nature. You guys know all of this. So that's GLBA. These are some of the penalties.
This is interesting. $100,000 for each violation, and up to 1% of the company's assets or prison. Hey, that's always fun.
Right. And this a lot of times is what information, or what are the specific facts of a case? Was it negligence or was it intentional? Right. So those are some of the things that this isn't necessarily you have that violation and you go to prison for 5 years, but is it, reckless disregard? You didn't care. I don't care. I'm not going to put any security in my system at all. I'm just going to collect this data. If there is a hack, I didn't even try to fix it. I didn't notify people, versus making mistakes, trying to fix it. You still, you may get a lesser.
So the point here, and all these slides will be part of the recording, right? The point here to us IT service professionals, us MSPs, for using the buzzword now, when we get pushback from our clients on implementing tools and help building what a good friend of mine, Matt, always uses, Matt Lee, cybermattlee.com. Matt uses the word defensibility, right? And I'm assuming you'd love that word, right? So building defensibility in yourself and in your clients by continuing to have better cyber hygiene and moving that needle. I like to use that all the time, moving that needle day by day, little by little, and educating your clients along the way. Like, hey, you're working with a small, family owned or small credit union. In this particular case, they go to jail, and because they don't want to do it, right? We always get that, I don't want to do it, or whatever the pushback is. Well, there are penalties.
There are big penalties.
5 years in prison might help. Now that we know that we don't want to take the FUD factor, but again, there is real ramifications.
Absolutely. So with that, not that it's on a lighter note, but this one is something you guys may again assist in implementing or advising clients when it comes to COPPA. So this really deals with any website or company that is using some type of this is even applicable to like toys that can record the kids video or audio. You can't collect any personal data of children 13 and under without the express consent of a parent. And it's a bit onerous, some of the requirements. Sometimes you guys may have gone to websites that have like that age. They ask you your age, and if you
usually bourbon websites, but we won't go there. I'll totally derail the conversation if we start talking about bourbon.
I don't know that bourbon websites would be considered.
No, but they'll have the "Are you 21 or older?"
Yes,
thing.
and that is something where it's like whether you directly target kids or you should know that kids will come to your website. Exactly. Right? My website, I don't think kids are coming to a legal website. Granted, I really don't collect personal data on my website, but kids aren't really gonna let me learn about data privacy and cybersecurity. Maybe not, but if I have like a cartoon and some type of entertainment, right. Yes, in all likelihood. And this also goes for mobile applications too and social media apps. So this is something where, let's say, for example, you want to register some type of, a child wants to register for a program. They may have to say, please get your parents to sign up. And then you have to have information for the parents to sign up, have their email address. Then the parents get an email and then get some kind of, link to sign up. So there are processes that have to be put in place so that parents can consent, can give their express consent before a company can collect a child's information. So this is going to be the fun stuff. The state privacy and data breach laws. Yeah. Here is exactly what we were talking about. California is leading the way. They, after
I blame Raven. Raven's a friend of mine that's on this. I blame Raven. Raven's from California. It's Raven's fault.
I mean, well, California is leading the way in the US. I would say globally, Europe has led the way. So shortly after GDPR was implemented, California said, you know what, CCPA has been called the GDPR of the US, with some slight differentiations. The subsequent 3 states that have implemented the comprehensive privacy law, they are very much in line with, the 3 are very much in line with each other, but really a large part of their requirements mirror California. But there's some distinctions between those 3 and California. California still goes a little bit further than the other 3.
Would it be safe to say if, like, when we're doing work with a client that would fall into CCPA or not, maybe they fall in Virginia, Colorado, or Utah, if we took the control list from California, you said there's alignment, and you probably, especially with Utah, that's literally not even 3 weeks old, looking at here's the controls in CCPA versus CUPA, and there's probably a lot of alignment, but there's probably either extra in California versus Utah, right? So as we as IT professionals, need somebody like yourself to help us interpret what are the deltas, how do we deal with them, and do we just, like, what do we do? Right? Yeah. And that's really the struggle that we have, is staying on top of it. One thing that was posted in the Q&A was, how do we incorporate like privacy by design in our IT systems?
Oh, that's a great question.
Ding, 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 you ring the bell.
So you know, the thought process of privacy by design, and this came up a lot in GDPR, and that's basically trying to incorporate privacy at the beginning of your development process versus sort of tacking it on at the end. As far as I
put you on the spot.
No, you know, and that's a great question. And, you know, that's something that I think maybe in a subsequent presentation, I would love to discuss that and get ideas. I don't know that I have the perfect answer. And it may be, you know, industry specific, product or service specific. And I think that, you know, having a platform to, you know, share ideas and say, hey, you know, this is what I'm seeing with my clients. And you guys can say, well, this is what some of our clients have asked us to do, or this is what we figured out to do. I think that would be a great discussion. And privacy.
Yeah, I have lots of thoughts about building your MSP with privacy by design and security by design.
I like that.
So
is that a future presentation for you?
Probably.
I would love to listen.
That's just how I live and breathe and die and preach. I mean, most people know, that are on here right now know, like, security by design. Always having a forward-thinking mindset of security first of how I approach stuff. And you know what? I refuse to work with clients that don't want to take the necessary steps to move the needle.
Yeah. I mean, this is a very, like I said, a very important area, and it's hot, and only more legislation is coming into this space. So here's again, the most recent is Utah, which was, as you mentioned, a couple of weeks ago. So most of these, California is still the only one that's effective, and that's the California Consumer Privacy Act that went into effect January 1st, 2020. The additional privacy laws in California under the California Privacy Rights Act is going into effect in January 1st, 2023. Virginia, January 1st, 2023. Colorado, July 1st, 2023. Utah is December 31st, 2023. So there's still time for at least most of these states to sort of get up to speed on the requirements and then implement any changes to processes and procedures for your clients prior to that date, to those dates.
Great, thank you so much.
Mm-hmm. So here are some of the main categories and what these state laws, as far as California has already done, and with the other three, Utah, Colorado, and Virginia, will do. They, just so that you know, not every single business is going to have to comply with these requirements. So the laws are available to all companies doing business in those states, and we'll get into that. All four states have given the consumer certain rights with respect to the consumer's personal information, personal data. Just as a quick explanation, California calls the personal information, collected personal information. The other three say personal data. I'm going to use it interchangeably within the presentation. All four states have an expanded definition of personal information, personal data. And when I say an expanded information, years ago, we thought personal information is just like name, address, and telephone number. It has been expanded to things including your online activity, biometrics,
email address.
Email address, it's been expanded. So all of them have a very expanded definition for personal information, and they all have a subset of what is considered sensitive information, which has additional protections.
Yeah, that's a really interesting point, because I've gone back and forth with some of my federal clients for months now on, particular work that we do. And much of the work is under freedom of information or public knowledge, like, school name or phone number. But because we have email address,
Yes.
it is now considered PII,
Yeah.
and all the PII restrictions and controls apply.
Are applicable. Yeah. And another category that I can put into the federal regulations, and that's FERC, and that's for education information. But since that's sort of like a smaller industry, I didn't necessarily include that. But the federal government also protects your educational information from certain institutions. And what you just mentioned just popped that in my head.
Yeah, so one of the questions that came up, which I think, and I know we're probably gonna run out of time like we always do, maybe we need to start in the middle next time, is when defining PII, is it just considered one single piece of information, or is it name, email, something else? Is it like
each piece of information is considered personal information? An email address, personal information, address.
Right, so maybe you can correct me, right? Because since you have the legal background that I don't, right? So I have tools that discover data on computers, and it will find an email address, a social security number, and a credit card, for example, right? It'll find, let's call it a Word document. And in that Word document, it's got their name, their email, their social security, and their credit card. So 4 pieces of information. Is that considered one record? So when you fall into a breach category, right, and you have to report number of records, is that considered one record or 4?
I believe it's considered 4.
That's generally what I've been telling people.
Yeah, I think it's because each is considered personal information. Now, if you go under some of the state data breach laws,
yeah,
they also have definitions for personal information, which you have to consider separately from just the state privacy laws, right?
Mm-hmm.
So, for example, if you have, sometimes you will have an account number or a username. If you have username and password, right? Some of them require like 2 things in order to be considered, personal information, and that's for the purposes of saying, that database isn't secure anymore because the person's username and password has been compromised. Whereas, and that's for state data breach, but that's still considered, under their personal information definition. But when it comes to these sort of the federal rules, and also the state rules, it's really, outside of California, and I have a list of what is the definition, but Utah, Virginia, and Colorado, it's personally identifiable information.
Mm-hmm.
My email address is going to identify me. My name is going to identify me. My address is going to identify some the individuals in my home. So each is considered personal information.
So as part of our MSP sort of prospecting and conversations we have with clients, either from a prospecting or from a risk perspective, really for me, for the risk is security first, right? So I do a scan, I find a bunch of email addresses and a bunch of phone numbers and a bunch of stuff, right? So one of the ways that we help our clients is to say, listen, we found 100,000 records in your stuff. Well, first, they don't believe us. Mm-hmm. Second, we actually show them, right? Here's one file, an Excel document with everybody's name, address, phone number, social security number, and email address. Well, if there's 100 records, email is 100, social security number 200, even though it's one file. and we show them the risk that they're exposed to just by one file gets duplicated, triplicated, whatever. And those, in the event of a breach, you know, those costs, like, oh, now you're getting hit with this sort of breach notification, this breach notification, and this one, that just gets compounded, you know, and their risk grows exponentially. One file.
So let's look at some of the differences between, again, the privacy laws and the data breach laws. The privacy laws, only California has a private right of action for a consumer to sue because my, you know, rights were violated. Yeah, right. My rights were violated under CCPA. For the state data breach laws, when the, you know, the attorney general is going to, of that state is going to pursue action on those particular, you know, violations. But when you're doing the notification requirements, you are looking for how many residents of that state whose information was breached. So if you have, you know, 300 records, but it may be from, you know, 300 pieces of personal information that was disclosed. It may have been only from, you know, 100 residents. Depending on what the state requirements are, you may have to notify them, you may not have to notify them. So it's like you have to read the rules and the laws specifically.
Why we need you.
Right.
That's why we need to partner and need somebody with a legal background that understands the law aspect around the privacy and breach, and technologists that can actually translate that into business processes and tools and technologies and safeguards.
Absolutely. And then when you also think about it, when you have your clients, the Federal Trade Commission is looking into an issue, they may also be looking at the pieces of information versus the number of individuals that, you know, because now it's just saying, okay, you have this, you know, all of my, like, my name is one thing, my email is another, if my bank account information, my medical records, my social security number. So all of that is applicable, and the requirements for maintaining that security to protect the personal information is applicable. So, you know, it all depends on the specific rule or law.
Of course.
Going back to some of the state comprehensive privacy laws, something that was done in Utah, Virginia, and Colorado is they specifically call out data controllers and processors, which is very similar to what GDPR did. That's not necessarily done in CCPA, but in CCPA, it's still the same process, same thought, you know, but those states, you know, really are aligning closely with GDPR by calling out data, just the controllers and the processors. There are data security requirements. California has very specific data security requirements. The other states have general requirements of, hey, we need to maintain security, you know, and have, you know, certain security, reasonable security measures in place. That's also something that's required by the, you know, over half of the states that have data breach laws. Again, these are privacy laws, and it includes some security requirements. And then the data breach laws also include security requirements. The data breach laws focus more on, now that there's been some kind of unauthorized access and data breach, you have to do these things. You have to figure out how the data breach occurred, how to fix it, you know, try to fix it, and then you have to notify people. In this regard, with privacy laws, it's really about what you do with the data collection as a company and how you protect it while you're doing your business, right? So we have a lot of fun stuff to think about in our industry. It's just coming from all sides.
We do. So cognizant of the time, we have about 10 minutes left or so. I know we just talked a lot about California privacy protection. I'm wondering if there anything you want to kind of maybe skip ahead to, or make sure that we get covered in the next 10 minutes or so.
So I'm gonna hop into GDPR. And talk a little bit about cookies. So here is something about the eligibility. So just so very quickly, for all of the 4 states that I mentioned, not every state, every company has to comply with the laws. In California, you obviously have to collect personal information, and you conduct business in California, even if it's online, but you have to either have $25 million in gross revenue, collect personal information from at least 50,000 consumers, households, or devices.
Is that annually? Yeah, it's
Yes.
annually. I'm sorry, I missed that.
Yeah, this one's annually. Or derive half of your annual revenue from the sale of personal information. And for California, sale means for monetary or other type of valuable consideration. So it could be exchange of data, exchange for services, or money, like some type of valuable consideration. For Virginia, it's a company that conducts business in California has to control or process the personal data of 100,000 consumers in a calendar year, or 25,000 in a calendar year, but you're also getting 50% of your gross revenue from the sale of that data. And sale for Virginia, I believe, is only monetary. I believe. Okay. Colorado, very similar to Virginia. And here for
Utah's the new one.
$25 million. You have to have annual revenue of 25 million, and then either collect data of 100,000 or more consumers, or 50% of your gross revenue comes from personal, selling of personal data, or processing personal data of 25,000 or more. So if it's a small mom and pop shop that's really not collecting a lot of personal information and doesn't have a lot of revenue, they may not have to worry about these laws. So that's something to also keep track of. But as though your clients are growing, you have to say, hey, by the way, remember these laws, you're, doing so well in all of these states. You need to think about it. Otherwise you may, step into some problems. So for the companies that have to comply with these states, you have these state requirements. Each state has rights, and I'm not sure if some of the people on this call have these requirements where they're going to assist the clients in setting up programs to comply with these consumer rights. Under California, someone has a right to know, opt out of that personal data being collected. They also have a right to sue for damages. Remember, California is the only state that has a private right of action. Virginia has, the right to know, to access data, to correct inaccuracies, the right to delete, the right to copy information, again, right to opt out. Right to avoid discrimination. By the way, all of these are in California as well. And Colorado, correct information, access information. So very similar. And then here, Colorado actually is the only one. Utah is the only one that is solely for monetary consideration. Virginia, Colorado, California, monetary or other valuable consideration for selling. Again, here we are. So monetary consideration only for Utah. And this is talking about some of what I was saying before about definitions for personal information, which we did discuss. The other states have very general information when it says information that's linked or reasonably linkable to an identifier or identifiable natural person, much broader. And I think time will tell, when the specifics would come into play. Here, these 3 states have again said controllers, very similar to GDPR, controllers, processors, and Virginia and Colorado require companies to now perform data processing assessments. Utah doesn't require that. California does not require that. I don't believe California requires that. That's not something generally recall. We mentioned this earlier about the types of agreements similar to BAAs, right? All of the states require companies to sign contracts with service providers. Again, this is going to include the information required. Obligations, comply with certain data security policies that a company may have in place.
Wow, there's an awful lot to consume just around the data privacy pieces, right?
Yep.
But
Yep.
only for 4 states as it stands today, and more on the list to come. So
I think the next presentation, I will focus on GDPR and the e-privacy directive, which is about cookies, and that's important and related, and you guys probably also deal with that, but cookies on a computer is also considered personal data in Europe.
Yeah, again, always great to have you. Always run out of time. I feel like next time we need to start at the end and work backwards.
Maybe. Yeah, I am about halfway, more than halfway through anyway. But Is
there any sort of closing nuggets? Again, we can go over a little bit. I'm obviously want to be cognizant of people's time.
Yeah.
Is there any real closing nuggets that you'd like to leave us with?
You know what? Actually, what is on this slide, I think, would be a great way to close. When you guys are advising your clients, and this is whether it's in these 4 states that I mentioned, whether it's in the EU or with respect to data breach laws in the 26 plus states, you want to make sure you advise your clients that they have to have reasonable security practices and procedures in place specifically for their industry and the type of data that they collect. Those written information security policies and procedures, and that's going to include what you guys are creating, the security, technical security measures, the administrative and the physical. They should review those, advise your clients, review those policies annually, train your clients, train their employees on the various applicable state, federal, and international privacy laws that are applicable to them. And then actively monitor their security and mitigate risks as much as possible.
You used my word, mitigate risk. Protect, defend, and mitigate is our motto. Protect, defend, and mitigate. I love
Awesome.
that. Does your slide, do you have an end slide with your contact info on it?
I do. So let me get there.
Well, fast forward to that.
Yeah, I'm getting there.
Or somewhere.
Okay, here's my disclaimer, and then here's my contact. My disclaimer, which I did mention, informational purposes.
Yes, we know that. Thank you so much. And I'll make sure that we put a little footnote when we post this. So
Awesome.
as always, we love to have you. Thank you so much for your valued insight around the law aspect. I am not a lawyer, and I would never pretend to be one on the internet or TV. This is why we have you. And so, the contact information is up there for anybody watching. Feel free to reach out. You obviously have mine. I am Tim Golden, the host of ComplianceRisk.io, and we thank you for your time, and we'll see you next Thursday.